phone out of you. All right, so what I'm going to do is I'm going to stand here because that's going to help with online and stand behind the microphone. Even though I have to tell you, this is not my style. If you know me, I like walking around. So that's what we're going to do, and hopefully, can you see this? Yeah, it's okay. Otherwise, we can dim it. I'm okay with that too. All right. Okay, well, let's get going. You want to do any sort of?
Welcome. Thanks for coming. We are excited to kind of get back into the routine of having these events. We have a small team that does some of the planning. Some are here, some are virtual. Do you want to introduce yourself?
Sure. I'm Celeste Parks. I have a daughter in 11th grade with autism, and she's blind.
Yeah.
I am Stephanie. My son is in 10th grade. He is autistic and has crazy ADHD.
I'm Amy Weber. I have an 8th grade student that was here actually on an IEP for a learning disability, but I'm also a DCD teacher at Becker High School.
I'm Dan. I've got a daughter that's 18 and graduating from Becker this year. She has a chromosomal abnormality that affects a lot of her processing and stuff.
I'm Cheryl. I have an adult daughter that has special needs and a grandson.
My name is Joan. I have an adult daughter who's in her last year of the Connections program here.
Yeah.
That's it. And she has autism.
Yeah.
You just want me to go ahead?
Yeah. So our hope is just to kind of share some information. We do have some people online joining us as well, which is nice to have that option for families that aren't able to come in. But we'll go through things, and as you have questions, I think our also goal is to start networking and having a network of people. So awesome. Thank you.
All right, well, we'll go ahead and get started. My name is Roger Strege, and I'm the president and owner of Special Needs Planners. And kind of some ground rules for tonight. Feel free to ask questions as we go along, and I'll do my best to answer those. I know we have people online, and I guess we're going to turn off the chat feature, but all the slides will be available later if you need access to those or need to share those with anyone that you might want to do that with. So let's get going, and let's see, who are we? Why are we here? Seems like there's always a connection. And for me, that connection is my daughter, Claire, right there, is with us tonight. She is 26, and in March, she'll be 27 years old. It's kind of weird to be saying that, but you guys will get there. Believe me, you will. And 20 months, she was diagnosed with autism. And so a lot of the things that you're going through, I have been doing for quite some time. And then also I have a formal education in this area. I'm a financial planner, and also I have a certification, a certified estate and trust specialist. So I have a concentration in this area, and I've really helped, I don't know, probably about 2,000 people do this over the past 15, 20 years. So feel free to ask questions. It's our time together. Do we have 2 hours? Is that what we're slotting?
Yep. Yes.
Okay. And if we use all of that, that's great. If we run late, that's fine too. So to summarize again, how old are your children? Are a lot, I heard 8th grade, and some are up to 18. Is that about right? Okay. Sound about right?
21.
And 21, yeah. So some of you have gone through this, but a lot of this you're going to be learning what it's going to be like in the future. So, all right. So first we're going to talk about some things that everybody needs to have if you're over the age of 18. And I mean that. So the first one is a power of attorney. Who has one of these for themselves? Okay? I know a couple of you do because we gave them to you. We made you do them. And I mean that. These are so important that the clients that we work with, I insist, is probably a better word than make you do them, but they're so important you have to have these done. And why are they important, and what are these things? So a power of attorney is a form, and I'll just put all this up right on here, that you use for what I call business decisions. Okay, so among those are up on the screen, so that's property, banking, insurance, talking to the county, and doing some transaction with Social Security. So I have a blank form, and I like to read some of these things off of here. Tangible personal property. So if you're going to buy and sell property, this is one thing that you can do. Insurance, changing beneficiaries, filing insurance claims and things of that nature. So for everyone in here, let's say you had a period of temporary or permanent incapacity and you did not have one of these, legally, even your spouse doesn't have a right to do these things for you because of HIPAA laws. So that would present a problem. And so that's why everyone over the age of 18 needs to have one of these. Now, if your child is under the age of 18, they're still a minor, so they can't do these duties by themselves, so you have that opportunity to do that for them. But if they are over the age of 18 and you haven't done any planning, what happens if they want to have a cell phone contract or talking to people at the county? And even at schools, they will have to have one of these because of HIPAA laws. And so with parents, I say, if you can't take care of yourselves, how do you expect to take care of your children? So everyone needs to have one of these. My other daughter, Taylor, lives in Minneapolis. She's now 28. And at age 18, when I redid mine and my wife, I made my other daughter do them. She was 18. She said, "Dad, you're such a dork." And I said, "You're welcome." And we've had to use it a couple times. When she was in college, she was an international student. She was over in Germany, and she kept spending money over and over again. Frankly, I was getting tired of it. So I was able to, because I had power of attorney for her, I was able to look at all of her transactions, and I could go to the bank and make deposits and withdrawals. Very, very simple thing, because she was unavailable. Literally, she was out of the country. Or if someone in April, they are traveling, but they forgot to file their taxes, you could do that for them. Also, for your child, I believe in least restrictive alternatives. So a lot of you are maybe contemplating guardianship when your child turns 18. Well, one of the things that you need to consider is least restrictive alternatives, and this is one of them, is a power of attorney. Doesn't mean you have to try it and fail, but it means you have to consider it. Like with my daughter Claire, we just said, well, she doesn't understand these concepts. It's very clear. It's not appropriate for her. But a lot of times, especially on the autism spectrum, people are higher functioning. They might get this, and maybe you want to try that first before you go down a road of pursuing guardianship. So that's one thing. Parents need to do it, and then maybe for someone who's a little higher functioning. Now, there's a couple of things to this. This is a voluntary document. So they are willingly saying, yes, I want mom and dad to help me if I need help. I need help with that contract, talking to the government. But they have to have sufficient mental capacity to understand what they are signing. So it's done in front of a notary. Their job is not a doctor, and they're not to look at you and ask them 20 questions, but it'd be simply something like this. So if you have trouble, you want mom and dad to help you with signing a contract or going into the bank. Yes, I would. And that's sufficient mental capacity. So again, consider that. The other one is a healthcare directive. Again, who has these themselves? Therefore, generally it's the same people, and the other ones that don't, they smile and they put their head down like you're doing, right? It's very common, don't feel bad about it, but everyone needs to have one of these. Again, for yourself, if you were going to the doctor's office, technically even the doctor cannot talk to your spouse. Now, are they going to turn a blind eye, or will they refuse care for you? Of course not. However, it's for their protection, because they don't want something to come back later, especially if you're dealing with maybe a brother or sister and they know that you're related, but then someone has a conflict later. So what is it? It's a form where you're going to name someone, and that person is called a healthcare agent. And so what you will say, I give my healthcare agent to act on my behalf if I am unable to make and communicate those decisions. So just because you have one of these doesn't mean that person can talk to the doctors if you can. We're going through this real time with my dad in Millbank, South Dakota. He's 94, and he's having some major health issues. However, he can speak, and he's lucid and clear. He's directing his own care, even though my oldest brother has this. So that stops. We're having a discussion, should we do this or that? Ultimately, it's his decision. Now, if he comes incapacitated, he doesn't have the mental capacity, that's why you have this in place already. Because let's say you didn't have this and it was your parents, and they were showing signs of dementia or Alzheimer's, and they can't make decisions for themselves. You didn't have it. It's too late to do this now. Then a court would have to be involved. So you do this when you're healthy. Hopefully you never have to use them. Then it says if I come incapacitated, this person has the ability to do this for me. So what can you do? Say, where do I go to the doctor? What type of treatment? Things of that nature. Also, there's a section in there for advanced care. And literally, here's a form. You check a box. If there's a reasonable chance of recovery, so let's say I'm going to have that surgery, but I might be out under anesthesia for a day, that's temporary. Permanently, let's say I'm in a comatose state, and you've already communicated this, then they will say, yes, I want to be resuscitated, or I do not. I want to be artificially kept alive, things of that nature. So you're not having an argument with siblings or children or anything like that. So important, everyone needs to have one of these. And then, is this appropriate for your child? Again, this could be an alternative to guardianship. Least restrictive, but it's a voluntary document. And they need to understand what they are signing. Could be as simple as you want mom and dad to take you to the doctor and talk to the doctors for you. Yes, I do. That's sufficient. Again, with Claire, she can articulate these things. It's not appropriate for her. But before you do guardianship, you have to at least consider these. So I'll get off my soapbox on no. But every time, if we do this again next time, everyone's going to raise their hand because you have one of these, right? Okay.
A clarifying question.
Yes.
So if you have guardianship, these two documents are kind of encompassed in that role?
So, Jared, question, if you have guardianship for your son or daughter, do you have both of these? You actually wouldn't need these.
Okay, that's what I need to know.
Because if you think about it, the very fact that you have guardianship says they don't have the mental capacity to understand these things. And so you have guardianship instead of these. But you want to try these first because these don't cost anything or a couple $100 at worst. They're not court supervised, they're voluntary, and you can tear it up at any time and do a new one. Okay, make sense?
Yes, thank you.
All right, let's move on. And this is one of the things that I'm going to talk about. I'm not going to go into a deep dive because this presentation, the financial piece is really 2 hours on its own, and it could be guardianship as 2 hours on its own. But I know you're at this, your kids are a lot of this age, and so I'm going to talk a little bit about this. Could someone hand these out? If you want to just grab. So I'm going to do this, so that goes in concert with that. So we'll go up on the screen, and then I'm going to read a couple things, and then this is important, what they're handing out. And actually, I need one of those back. I made 20. I think there's going to be enough. So, all right. Thank you. All right. So guardianship. How many are familiar with that? You haven't gone through it yet, a lot of you. Have you?
Yes.
Is your daughter 18?
18.
She's 18, so you went through. Okay. Wow, we got a whole bunch of other people that just came in. So, all right. So, what is guardianship? So, guardianship is a process where you're going to say, because of my child's condition, they need someone to basically look after them. That's kind of an overall 40,000-foot view. I'll let everyone settle down here. So, if you did you go to the wrong room? There's a whole bunch of you at once. Did you hear that? She said, we're in the wrong room. Get that.
I'm so sorry. They changed
Into the
it
right.
on us last minute.
Yep.
We were just watching you on YouTube while you were at YouTube Stars.
Oh, okay. There you go. Did you put like I had hair on me or anything on YouTube? No? Darn it. All right, so we're going to go. We're just we're segueing into guardianship. So, guardianship is a process that you may want to do for your child. It's when they turn 18. And why could that potentially be an issue? So, in the state of Minnesota, someone who is 18 is an adult. And so that means legally you have no right to control them, in a nutshell. So if they want to move out, they could do that. And if you go to the doctor's office, because of HIPAA laws, you can't speak for your son or daughter. Talking to the schools, actually, at age 18. You don't have a right to do that. So this could be problematic. And so why would you want to consider that? And so you can help them. So that's kind of the spirit of it. And everyone got the handout, so we're just going to talk about this. So types of guardianship. There's a general guardianship where essentially you give all the powers to the guardian and so they can help them, or sometimes we do limited guardianship where there's certain powers and you may just choose 2 or 3 to try to customize that for your child. I usually recommend that you just grant all powers, and just because you have them doesn't mean you hold this over their head and say you have to do this or that. I like to use a lot of analogies, and actually those of you who didn't come in at the beginning, my daughter Claire is here with me tonight. So she was diagnosed with autism at 20 months, and she's now 26 and will be 27 in just a few weeks here actually. So at age 18, and since then I've had guardianship for her, so I know exactly what it is. But basically, I like to call it a safety net, or if you go bowling, put the bumpers out, but if you're throwing strikes, you don't even know the bumpers are there. But if you're headed for the gutter, it kind of guides you back in. So that's how I kind of think about this, is that it's always there to help. So I'm going to read something right here because it's not on the screen. So here are the basic duties that a guardian can have. So I'm going to do that. I'll read these and I'll walk you through the process. So the guardian of the person. So my daughter, actually, she is my ward. Have you ever heard of that? And so some people who don't have a parent as a guardian, they might be a ward of the state, if you've probably heard that. So that's really what it is. So I'm the guardian, so parents will be guardian, she would be the ward. So you have the help them make decisions in the following areas. So general care and needs and where to live. So other people say establish a place of abode. You can say where they're going to live. So that's pretty important. So if they say, you know what, for whatever reason, I want to move out because I don't like you or such and such, but you know that's not in their best interest, you can say, okay, you're going to stay at home or a group home or that apartment. So care, comfort, and maintenance. So what does that mean? Food, clothing, shelter, health care, and also social, recreational activities, training, education, or rehabilitation. It's pretty encompassing, but basically, you're going to help them eat and you're going to help them go to the doctor. It's really what that means. And we were just talking earlier with Dan, Special Olympics. You know, she's into all these things. Is wonderful. That's the activities that you're going to line up for them if that's what's important. Reasonable care of personal effects. So that means you want to make sure, you know, they have a safe place to live and they are properly clothed, their room is safe, things of that nature. Necessary consent for medical or other professional care, counsel, treatment, or service. So you're the one that says, yes, we're going to go to the eye doctor and they need the new eyeglasses. Yes, we're going to go in and they're going to have oral surgery. They're going to have that surgery. You're the one making that for them. Just took a annual physical, same thing. Are there any medications? You're the one that says, yes, it's appropriate for them because they can't make those decisions themselves. And here's one that's important, is approving or withholding approval of contracts, except for necessities. So what does that mean? And I like to illustrate by example. So let's just say your son or daughter is 18 and they want their own cell phone. So they went down to the cell phone store, and guess what? Their buddy went with them. And he talked them into getting a plan for both of them. And they ran up all these gaming charges, and it's thousands of dollars. This actually happened, by the way, so that's why I'm telling you this story. So, but he had a guardian, was his parents. They saw the bill, and it was $2,500. He doesn't know what he's doing, okay? He got talked into it by his friend, and they were able to prove he didn't have the capacity. They were able to void that contract. So there is some kind of after-the-fact thing, but hopefully you head that off. So that is something that could be extremely important. And then exercising authority, which limits civil rights and restricts personal freedom only to the extent to provide needed care and services, meaning to get them out of danger. Does that make sense? Okay, and then did you get this, the Bill of Rights? This is really important because even if you have guardianship, this says the ward has certain Bill of Rights. I get these questions all the time, and a woman just said, I want to pursue guardianship. She called me up and said, no, I'm not going to because my daughter can't vote then. And I said, well, that's not true. So if you look at on here, and I'm just going to kind of highlight a few things. And number 15 on the back says they still have the right to vote. So that's something that's important. I think it is. They can still vote even though you have a guardianship over them. And I want to look at number 12 because this is top of mind for a lot of people, and I understand why you might want to consider that. And that would be sterilization. So I just had a client ask me, can I take my son in because I have guardianship over him? And I said, no, you cannot, unless that is specifically approved by the court, above and beyond having guardianship. I don't know what that means, but you'd have to really, really prove that it's in the best interest of everyone that you have that taken care of. And especially, if you have a daughter, that one might be a concern of yours. So, but again, that's separate above and beyond. And also they can marry unless there's a court order that says you cannot. So just because you have guardianship, they still have a lot of freedoms. So does that make sense? This is just good reading. I think it's important to know that. So how does it work? So first of all, when should you start? I usually recommend 3 to 6 months before your child turns 18. And the reason for that, the court is actually the long pole in the tent, so to speak. We don't know what the court's schedule is. Actually, because of COVID, it's shortened it up. I don't think we're ever going to go back to in-person in court. Even the judges like it. And that's better for you and your family. I don't know if you've ever been to the courthouse. I've been there many, many times, even though it's simple things. I always get nervous. No one wants to go. It was 8 years ago when we took Claire in. The whole thing was fine, but you have to go through this process and plan for it. So now everything's done via Zoom. Okay? So that's kind of how it works. But start before then, 3 to 6 months. And I say seek qualified professionals. You as the parents, if you're going to be guardians, highly recommend that you have an attorney represent you. Can you do this yourselves? Yes, you can. I don't recommend it. I've done this for years. My attorney did it for us. And some people, they've tried it, and then they literally got all these stack of forms and then said, this is too daunting. We don't want to do it. Have any of you tried it yourself? I'm just curious. Okay. I know some of you have gone through it. But again, it is up. You can do it, but I highly recommend you don't do that. So you have an attorney representing you as mom or dad or whomever it is. And so they will work with you, and they put together something called a petition. Essentially, it's reasons why this guardianship is appropriate. And they're going to collect medical records for that, the latest physicals, everything that you've had probably since they were a kid. You're going to collect all of that data. Then they will submit that to the court in something called a petition. Essentially, you're saying all the reasons why we need this. And it would be, can I be left alone? Needs 24/7 supervision. Is a harm to themselves or others? You essentially have to prove it. So that goes to the court. And then, along with that physician's report, then a couple of things happen. And this varies depending upon where you live, availability, and frankly, what your child's needs are. They will assign a court visitor. This is someone that is employed by the court. It could be an ex-judge. It could be a county caseworker. It could be someone who's retired or someone actually employed by the county. In Hennepin County, they have 2 full-time workers. That's all that they do. When they come out and how they do this, it's up to you. Claire never had a court visitor that visited us. I don't know why. Maybe they were busy, they didn't think she needed it, I don't know. But the point is that they will do that. They check a box that says due process was served. So they will come out, schedule, and do an interview. And the purpose of that is not to have your child tell 100 things that are wrong with them. It could simply be, how are you today? Who's all here? And if it's yes, no, or they don't speak, they're pretty good at that, and they'll check a box and then they move on. However, your child can say anything that they want. Anything. That's the whole purpose of it. And that's just recorded and given to the court. In addition to that, your child will be represented by a court-appointed attorney. This is not yours. It's someone that the court will provide as part of the service. Why? Because they have to be fairly represented. I think with most of the guardianships that we see, they are not contested. However, if that's something that your child really doesn't want to do, but you know it's best for them, but they're going to give some pushback, there's their opportunity to be represented. Also, with elderly people, Alzheimer's and dementia, that's really where it comes into play. They need to be represented fairly. So again, they may come out and visit with you, They may schedule a Zoom interview, I don't know. With Claire, we met this woman 20 minutes before our court case. I can still remember it like it happened yesterday. We're at Wright County Courthouse, and this woman walked in. Boy, she looked good. She smelled good. She had high heels on. She came in. I'm Claire's attorney. You should see my wife pounced up. She's like, who is this? To talk to my daughter. I sat in the corner, and I can overhear this conversation. Yes, lady. No, lady. That was the interview. Okay? But check the box. Due process was served. Now, for some of your children, it may be more involved than that. They can tell anything they want to make sure they're fairly represented. So that is part of that process also. Then you will have a court hearing. And depending upon where you live in the court schedule, this could be 3 weeks out, it could be 3 months out, first Friday of every month, whatever the case is. But ideally, you want to have this right before they turn 18, so in case there's something that comes on, it's in place. You can do this up to 6 months before their 18th birthday. So most of these now are basically a non-issue. They will take a census of who was all there. So it's mom and dad, anyone else interested. Any adults in the family or caseworkers have a right to come to that meeting also. And if it's via Zoom, they will get an invitation. Everyone can sit in, family, friends, whomever you want it to be. Most of them are pretty light attended, and they generally go very quickly. But literally, day in court, your child can say whatever they want. You can say whatever you want. Most of the time, it's already a foregone conclusion the judge already knows, and they usually take about 5 minutes. So hopefully that happens to you. And actually, the work is done ahead of time. It's talking to your child, letting them know what's going on. Make it seem like, this is something that you do when you're 18 so we can help you. Give them examples. Take you to the doctor. Talking to the county, filling out forms. No one likes that. It's just helping them. So let's say that it all goes smoothly. They will sign an order, and you will be issued letters of guardianship. And so then, when you go to the doctor's office, county caseworkers, you present that. Generally, they scan it, and they have it in their system, and that's what you do now for foreseeable future. Annually, there are reporting requirements. You have to do something called an annual report of well-being, and it's a month after their anniversary of when the guardianship was in place. And then also there's an affidavit goes out to all interested parties. And so literally you can say, you know what, we reviewed this and we don't need it anymore. There's a chance to do that every year. And there's very recently now the guardianship is for 7 years. Then you're going to have to go through a recertification now. 6?
Yeah.
Oh, it's 6 years. Yep. Now before that, it's very lifetime, but now it's every 6 years. So it's
Until they're 30, I believe.
It's fairly new, and I haven't had anyone gone through it, but that essentially the process would be the same. But once you're in, it's now people you generally ask, do I have to do it at age 18? No, you don't. For example, and I just talked to some clients yesterday. They said we're going to do guardianship. At the end of an hour meeting, because we talked about the healthcare directive and power of attorney, they said we're going to try that first. Let's try it, see how it goes. I think that might work, and I like that, and they liked it too. 6 months if it works, don't know, but then you can always do it. Okay, question?
Question on if you wanted to change who are the guardianship. Right now, my husband and I are for our 40-year-old
Right.
daughter, but we're looking at transitioning to her sister in the future.
Mm-hmm.
What's that?
So good question. I'll just repeat that. She says, how do you go about changing guardians or adding guardians? So for example, it's typical that, if you have a mom and dad, that they're co-guardians. So that's together. And you're at presently. Then you might nominate successor guardians in your estate plan that says, if we passed, I nominate such and such. But they're going to have to go through the guardianship process if you've done it that way. So if you're co-guardians, if either one of you passes or resigns, the other one just takes over. That happened to me about 2 years ago. Right? So now I'm sole guardian of my daughter. Just had to let the court know that my spouse is deceased, so now I'm just the guardian. Okay? If you want to during your lifetime, you can add people. So, but they would have to go through that similar process through the court. But if you're being proactive in doing that, then that saves a headache down the line. So I like your reasoning. Ideally, you want someone younger. and then a peer or something like that, so you might want to add them. So if that's part of your family plan, it's best to do it while you can. Because let's just say, God forbid, that both of you died simultaneously, then what would happen? They would work with the county to make sure your son or daughter is safe, all right? There are temporary guardians from the county that will step in and they'll say, okay, where are we living? Who's going to help take care of them? Brothers, sisters, neighbors, they'll make sure they're okay. They have caseworkers. They'll do that for as long as it takes. Then they'll bring in another guardian, family member, or there's professional guardians that could serve in that capacity. Does that make sense? That's the difference. You have as many as you want, except just from a logistical standpoint, if you had 4 guardians and one's in Kentucky, probably wouldn't work very well. So just think about that. All right. Good on guardianship? All right, now we're going to talk about programs and money and things like that. So, medical assistance, how many are on that in some form or another? Probably half of you. Okay, for those of you that are on it, this will be a little bit of review. But for those of you who are not, I'm going to talk about what it is, what some of the programs are in the medical assistance, and why it's important for your child. So people usually call this MA. He's just saying, are you on MA? No, I have a waiver. Well, then we have to take a step back and talk about what MA encompasses. So MA is a medical assistance. It's actually a Minnesota program. It's part of a Medicaid program. And the whole idea, it is for persons with low or no income. It's the idea is to try to help. It's administered through your county of residence. Are most of you in Wright County? Some Sherburne County? Yeah. So it all works the same. You just have a caseworker in the county of residence. So that's what you will have. And you may have one or more caseworkers. Depending upon whether your child is a minor or an adult, they may split up the services. You may have a financial worker, but they're all employed by the county. Some counties outsource this to third parties. Pinnacle is one I've heard a lot of. You'll have someone to help you. First and foremost, it's for medical needs. If you are employed and your son or daughter is on your employer-based program, that's fine. Then we have what we call coordination of benefits. You could have both of them. So if you have employer-based and it covers most things, but it doesn't cover a copay or a therapy or a certain medication that's not on the formulary, MA would pick that up. Claire's been on MA for over 20 years because I'm self-employed, so I don't have that. It covers everything. It's a good program. It's actually underwritten by Blue Cross Blue Shield or whomever it is. So that's what it is. First and foremost, it's medical needs. Also, with a lot of employer-based programs at age 26, your child can't be on your plan anyway, so you're going to fall off. So, other things. Some of these look familiar. Caddy waiver, CDCS, DD waiver. To me, it's alphabet soup. It's like NFL on Fox. I get confused. The bottom line is these are programs that can help your daughter or son, and you probably have a budget. Some of you have a budget. Yep. Hers goes up at the end of February, so I'm redoing it for next year. So I'm knee-deep into it. So what's in it? You may have hours. So you may have PCA hours, personal care attendant hours. So if you want to go out or someone for on a date, you may have respite hours. Or someone could come in during the week and take your daughter or son to appointments and whatever that they need to give you a break, or so you can go to your workplace. In my daughter's budget, there's 39 hours a week or personal care attendant hours. So that really helps. So you add all this up and there's a budget. So hours are the main component. There's going to be this healthcare piece. There may be some other things. For many years, we had a membership at the Monticello Community Center because it helped with activities, strengthening, things like that. She was young. We had an iPad with autism apps to help her speak. You will work with your caseworker to determine what is appropriate. They will do an analysis, so it's all the doctor's records that you have. What are her needs? IEPs, they'll work with the school, and they'll come up with a plan. So there's a written plan. It's kind of like an IEP, like that, except it's personalized. And they'll come up with that along with hours. So It could be literally thousands of dollars, $50,000 or $60,000 or more, depending upon your child's needs. So this is very, very significant. So how many of you have a budget now that you're actually, right? So does it sound familiar with what you're talking about? Yeah. So that's good. Also, depending upon your needs, there may be housing assistance. So if they're going to be in a group home and some of the dollars aren't covered, they may pay them in the background. Or they used to call it Section 8 housing. I don't know if there's a different name. But if you can't afford to live in there, the government will supply that. And also food assistance, EBT or food stamps, what it used to be called. I don't know if it's on a card now or something like that. But those, pardon? SNAP, there you go. Another acronym. Point is, all this is part of MA. So if someone says, I don't need MA, I'm just on a caddy waiver, MA is up here. It's like an umbrella or a gateway to other services. All these things filter under it. So I'm going to talk about asset limits. So your son or daughter can have no more than $3,000 after the age of 18 to qualify for this. So they may qualify just from a healthcare standpoint, but when you apply and they're over the age of 18 and they're over $3,000, you'll be denied right away, period. So what counts, this is just their personal assets. Over the age of 18 has nothing to do with family members, even if you live at home. So it's their checking, savings, cash. If they have a 529 plan, that could count against them, anything like that. So this is a problem, as you can see. So what if you want to give money to them, or $3,000 isn't a whole lot? This is a problem. We'll talk about how to fix it. But my opinion, MA is the single most important that we need to protect. Because as long as you're a resident in the state of Minnesota, this is for a lifetime. And if you do move counties, you just get a different caseworker. So this will literally be millions of dollars over a lifetime. I have some clients where they have a particular shot that's $10,000 and they have to go every month. Imagine if they weren't on MA. Imagine that. So, question?
Just to clarify,
Yeah.
Get MA though, you have to get through the process of getting considered disabled, correct?
Correct. So,
right now in our situation, so she was rejected by the county, now we're going through SMRT.
yep, another good acronym. So how do you qualify? You can just go into MNsure, the county caseworker, and do it that way. SMART, you've heard of that. State Medical Review Team is what that is. It's a formal analysis. And if you have been SMRTed, then you automatically will qualify for medical assistance and also Social Security benefits, which we'll talk about in a minute. But you don't have to have that. But if you do, then it's kind of like a key that takes you everywhere.
That's with both of them, we're waiting on the SMRT and the Social Security
Yep.
right now. I mean, it's
Yep.
only been 2 months.
It's a process, and it's based upon your child's individual needs. Some have higher needs, and so these are just some tips I've learned throughout the years. When you do all these interviews and you're filling out forms, be truthful, of course, but describe your child on their worst day. Like for Claire, needs 24/7 supervision. Can I go outside and mow the lawn for half an hour? Sure, but I have to come in and take a break and check on her. But the point is, do that and say, cannot draw a bath by herself because she will be burned. That is true. Okay, so these types of things, make sure you're doing all of these to make sure they really know what's going on. And that will just kind of help. Yep. But yes, so if it goes to the SMRT analysis, you automatically will qualify from a healthcare standpoint or just go through their process. So for assets, again, $3,000, not a whole lot. Technically, your daughter or son could own a home and still qualify. And they could own a vehicle. If they drive, that's allowed. But let's just say they owned a car and they sold it. Now they'll have too much money. They'll have over $3,000. So you need to think about all these things. Or a home, if you gifted that to them, they live in there, but then they sold it because it didn't work out, they would be ineligible. So does that make sense? So MAEPD, some of you heard of that. That's MA for employed persons with disabilities. Obviously, we want to encourage our children to work. I think that's wonderful. There used to be a $20,000 asset limit. If you're working now, that is lifted. And so, if someone is working, it's just, literally a month or so ago. So we want to encourage that. So if someone is working, there are still limits from income, and that's really from the state, and it's about $1,000 a month. So if your child is working, they have part-time income, or they still need MA, they may have to pay $50 or $100 a month co-insurance to get medical assistance. Still well worth it. But again, here's a caution. Let's say that they have a job, that's great, and they have $50,000, 10, whatever it is. But they lose their job and now they're on regular MA. Now they are over $3,000. So again, you need to think about all these things where it could present a problem. So that's MA. Let's talk about Social Security. There's different types of Social Security. So for a lot of us in this room, when we retire, hopefully we have Social Security benefits, right? So that's based upon our work history. The more you make, the more your benefit is. There's other types. There's retirement and survivors. So if you pass away or retire, your daughter or son could get a benefit based upon yours. One right here is SSI. It stands for Supplemental Security Income. It's basically meant for persons because of their diagnosis cannot work. In Social Security, it's their definition. They're trying to see is can you work? And if you cannot, they're going to help you out. That's the whole intent of this program. So it's administered by the Social Security Administration, federal program. So as long as you're in the United States and you qualify, this benefit is for your lifetime. Claire's been on this since she's been 18. Exactly how it works. She gets a monthly payment on the 3rd of every month, comes into her checking account. What's the whole idea? It's for basic food and shelter. So make sure they have food in their stomach and a roof over their head. That's what it is. Okay, because they can't work, Social Security Administration says we're going to help you out, no matter where they're living. Maximum this year is $943. As the cost of living increase, it might go up a little bit each year. That's the maximum. And I'm going to try to give you some tips that will help you get to the maximum. Oh, it's on here. So asset limit is $2,000. Here. Apply at ssa.gov. You can go online and start a application. When should you start this? I recommend you do this the month after your child turns 18. You can't do it before because it's based on parents' income and assets. You wouldn't qualify. So I would do it the month after because then there's no confusion with Social Security. That part of the month, 17, 18. Claire's birthday is March 20th. I applied on April 1st when she was 18. That's how you do it. Go online, ssa.gov. You can call. Used to be you could go into the Social Security Administration office. I would not recommend you do that. For one, my experience, they aren't very pleasant places. And plus two, I don't even think they're open. And three, if you walked in, they would say, great, we'll schedule a phone appointment in 3 weeks. So I would call them up or do it online. Start the process. Again, it's data. If you have a SMRT analysis, I want to say it's a slam dunk that you will be approved. But they're hard. A lot of times, especially if you're on the autism spectrum, you'll get denied 3 times. Usually 3rd time's the charm. Why? They're trying to vet out people who just don't want to work because they're lazy. Sorry, it's just that simple. So that's what they're trying to do. So again, describe your child on their worst day and paint this picture, which is accurate, but just give them kind of the bullet points. Also, to get to that maximum, they're going to ask you a lot of questions about where your child lives and what they pay for expenses. If they live with you, they're going to ask you, what is your monthly rent or mortgage payment, light, heat, etc.? How many people are in the household? And what of that does your child pay? If they're not paying anything, then they're going to say you're giving them in-kind food and shelter, so we're not going to give you $943. They will reduce it. So how do you get around that? 2 basic ways of doing it. First, I'll tell you the way that I recommend you don't do it, is that you take all of your bills and you divide them by the number of people in your household. So if there's 4 of you, take the mortgage, divide it by 4, light, heat, utilities, Netflix, whatever you have. And if you go grocery shopping, have a separate cart and buy their own food. Will that work? And you can prove, yes, they have $700 a month in expenses. It sure will. It's an administrative nightmare for you and for Social Security. Frankly, they don't want to see it. I recommend charge a flat fee, and I've been doing this for years. Flat fee, call it room and board, charge it once a month. There's no magic number, but $750 seems to be a good amount. They're trying to make sure it's reasonable. I have families that charge the whole $900. Good luck trying to find an apartment for $900 and food, right? They will not question you on this. They may ask you how you came about it, and you can just say apartments in the area, something like that. Highly encourage you, because then they will say, yes, they're paying their fair share, and so we're going to give them that $943. Whether you need the money or not, or they live with you, isn't the point, but we're trying to maximize the benefit that they can have. Okay, that makes sense? All right, $2,000 asset limit. Again, that's all they can have. And I back that up because that is a hard stop for Social Security. That's an asset limit. Total of everything, any point, any given month. Let's just say your child has $1,500 in their account, below $2,000. $943 comes in. For one day, if they have $2,400 because your rent check didn't clear, they could suspend or remove it. And they'll make you start all over. You have to reapply. And you think it's hard applying right now? Wait if you have to try to do it. I'm not being cheeky. So she has between $300 and $500 every month. Room and board comes out, and we go shopping. She likes puzzles. We go to Five Below. We go to Marshall's. You spend these things, right? Use those dollars because they're there to help take care of your daughter or son. Okay, that makes sense? Representative payee manages that account. That can be the person themselves, but I would probably recommend one of you do that, which means you can talk to Social Security, you control the account, your name's on it, you write the checks, have a debit card, buy things for your child. It's just that simple. If you are a parent and the child lives with you, there's no reports that are required. If that's not the case, it's simple, it's once a year. Very, very easy to do. Major buckets what you spent the money on. First one, housing, food, and shelter. Well, if you're charging $800 a month, multiply that by 12, that's your first line. The next one is other. I put everything else in there, and then what you saved. So I'm not talking $5 or $10 here. So if you do that, that's all it's very easy to do. Good to know SSI payments are not taxed. If this is all that your child has, you never even have to file a tax return. It's a different type of benefit. They're not taxed as wages. So a great benefit. All right, questions on that? Move on. Okay, so $2,000 is not a whole lot of money, is it? So what happens if you want to give your child money? We're going to talk about that, why it's a problem, and how to fix it. How are we doing on time, by the way? I can't see that clock.
6:54.
Not bad. We're about an hour into this, right?
Yeah.
There you go. Do I have 2 hours up here?
Yes.
Really? You're gonna put up with me for that long, right? Okay. Anyway, so here's what we're gonna do. So let's just say we have a family, and there are 3 children, and we have 2 parents, and one of them has a disability, and so they are on SSI and MA. That's the whole idea here. So what happens when one spouse passes? Generally, assets pass back and forth, generally not in fact impacting the kids, but what happens then? The surviving spouse passes. Do they have a will? Don't know. Do they have beneficiaries? Don't know. Typically what happens, any portion that you want to give to your child, that would put them over their limit, obviously. So that's a problem. So how do you fix it? One solution, and I call this the dark ages. We haven't had to do this since 1991. You can disinherit your child. Say we give them nothing. What we're going to do is we're going to give their portion to their sibling. In this case, her brother. He's good with money, and he loves his sister, right? That account that he has can not have his sister's name on it whatsoever. It can't be a joint account. Can't be associated with her at all. Even if it's a joint account, that asset is considered to be 100% available to them over the limit. So legally, can you do this? Absolutely. In all the years of doing this, we had one family that did it because they had 11 children and they thought they could keep an eye on each other. But that's it. So will it work? Sure, but What about some problems? What if the brother dies? What's going to happen? Well, we'll go to his spouse and children, right? It'd have to because the daughter's name isn't on it. What if he becomes divorced? State of Minnesota, what happens? Ex-spouse gets half. Half of that's already gone. What if he becomes disabled? Now you have two people lost their benefits. And what if he has financial trouble? He files bankruptcy, all those assets would go away. So, again, not a good solution. So, this is what we do. We do about 30 to 40 of these a year. This is what my daughter's had for 8 years. So this is something you can do now. The earliest one we've done this was a child that was 2 months old because they had a traumatic injuries at birth, and they had a family plan with grandparents. They're going to live on a farm, elaborate plan. The latest you can do this is age 64. Can't do it when someone is 65. So how does it work? So what we do, we create something called a supplemental needs trust, and also we get wills for parents. How many of you have wills? Okay, and I know some of you have trusts because they helped you with them. So we do this all together at one time because they draw big circles around each other, and we're going to cover every single base. I want nothing to fall through the cracks, any scenario that you can come up with. So in your will, it says anything not otherwise specified, meaning doesn't have a beneficiary on it. We forgot something. In the will, it says my daughter gets nothing outright. Instead, if any portion to her is directed to her supplemental needs trust. So we stop it there. So that's a good thing. But then also, what we do is we're going to remove her name from all of your accounts. And you're going to change it to the trust name. So that way, when you pass, it's already taken care of. You can set these things up, hopefully it's many years, and they're just waiting. So then when you pass, the supplemental needs trust gets the money, not your child. So what are some characteristics of the supplemental needs trust? First and foremost, it's what we call third-party funded. What does that mean? Never, ever, ever can your child's money go into this, period. Cannot be their own money. You can't take their Social Security money and put it in there. You can't do that. First rule, anyone in the world except your child can put money in here. Grandma, grandpa, I could put money into that. Okay, that's the rule number one. And typically, parents or grandparents create this. Actually, anyone can create it except the child themselves. A legal term, you're actually called the grantor or settler. You're the one setting up or granting the rights to the trust. Your child does not have access to this money, period. They cannot make a distribution. They can jump up and down and say, I know this exists. And your job is to make sure that is in their best interest, but they can't have access to the money. If they did, it would be considered an available asset and it would be counted against their eligibility. So they can't. It's managed by a person or persons called a trustee. Could be an organization, could be a company, but they can't do it. Most important thing, the child never gets money from the trust. They can't take a distribution. You can't give them money, cash from it. The trustees buy things for them. So for example, let's say you want clothing. You're going to go on a trip. You could use the trust dollars to buy that trip. You're buying it for them. That's how it works. How does it work? Part of the process we get from the IRS, a tax identification number that is unique to the trust. It's actually an employer identification number. That's what EIN means. They treat it as a small business. It's a separate entity. Why is that important? The assets are not yours, so they're not titled, tracked to your Social Security number, but more importantly, are not your child's. That's the key. So it's not their money. So when you're doing, and I get this all the time, and I'm gonna tell you 10 or 15 times. This is very important. When you do your renewals for MA and Social Security, they will ask you, in the past 6 months, did your son or daughter create a trust? The answer is no. It's just that simple. Well, it's their trust. It's not. You have done this for parents. It's part of your estate planning. They're the beneficiary, but it's not their money. They may never get a distribution. They can't touch it. And I've had people say, well, Social Security's giving me a hard time. Why is that? Well, I have to give them a copy of the trust. Why? Well, they know about it. Why? Well, I told them. I said, well, didn't I tell you 6 times not to? Well, I felt bad. Or they tricked me or something like that. They will ask you in a play. I know, and I'm not being cheeky. I'm telling you. They will ask you in a way that sounds like you have to disclose it. There's nothing wrong with it. But I'm trying to save you a heartache. They will make you provide documentation, copies of the trust, all the distributions, what was funded, et cetera, et cetera. In the meantime, they will suspend your Social Security benefits, but some up to 3 years. So you're losing all that out. And at the end of it, they said, thank you, this was properly drafted, we didn't need it. All because they said, yeah, honey, back in 2019, didn't we create a trust? That's because Social Security and MA, they don't know about the types of trusts. There's different kinds. So yes, if it's a grandparent family trust where they get money each month to their own person, that is countable. That's a legitimate question. So just a tip for you. The answer is just no, and you move on. Separate tax ID number managed by trustees. Why? They maintain their eligibility for MA and SSI. It's just that simple. It's not countable. It's not zero. It doesn't exist for them. Another thing I like about this, there's no reports that are due to Social Security, medical assistance, or the state because you don't have to report it. Private family transaction, period. And it is for their sole benefit. Helps protect their vulnerability. Had lots of stories, and one that is a little hard to believe. We had one of these cases where a person had a trust and they married their PCA. Seems a little weird to me to begin with, but anyway. And so that was going fine, but then later on, lifestyle didn't really fit, and the person that they married knew they had this trust and wanted a convertible and said, well, that would be a great thing to have, right? Well, it wasn't for the person's benefit, it was for hers because that wanted her lifestyle. So what happened? Got divorced and said, well, I get half the money in that trust. Absolutely not. That's protected. It's not their child's money, so it helps protect them from vulnerability. And let's say personally they got into trouble. That cell phone bill, and they owed money or they had bankruptcy personally, cannot come after the money in the trust. Completely protected. So it really is a safeguard. And we fund it upon creation. So what we do, and some of you have done this, we put $20 the date we sign it. The reason we do that, Social Security says to be a valid trust, it must be funded. And then from there, you open up a bank account and things like that. What's in it? These are just examples, depending upon your family. There is no limit to what can be in this trust. There's no timing of what comes in, the amount that comes in, who it comes from, or when it comes out. Claire's never got a distribution from the trust. Frankly, there's not much in it. Part of my estate planning, most of it is going to be by beneficiaries. Life insurance. That makes a good way to go to a trust. How do you do it? Once you set up the trust, you get the tax ID number and the date that you sign it. Now that's unique to that trust. So once you get it in place, then you get a change of beneficiary form. Your life insurance, your 401ks, they all have beneficiaries, correct? So then you want to update those. I have 2 daughters. Mine says 50% goes to my daughter Taylor, 50% goes to Claire's Supplemental Needs Trust. Repeat that process for every single account. The percentage is up to you. If you want to give equally to all your kids, fine, on one. For me, I'm going to give life insurance to Claire, other assets to my other daughter, because it just works out tax-wise. But that's up to you. And those you change any time that you want. It's your money. But you're doing this ahead of time. Now you've got all these things in place. Also, again, in your wills, it says not otherwise specified. What's that mean? Doesn't have a beneficiary on it. So we missed something. Fell through the cracks. Stops there. Outright, we missed it. She gets nothing. Again, directed to her trust. So we stop it in all these ways. Again, no limit on contributions. It's whatever you want to do. These are examples of what the trust can own. So what we do is we get the trust in place, give you everything you need, and it's within a month, go to your local bank or credit union, open up a simple trust checking account. If you're the parents, you're the trustees, we give you everything that you need, copies of the trust, what the bank needs, you hand them the information. And I like checking, and I know people don't write checks much, but get a sample book and a debit card for you as trustees. Now you're set. If that's all you do for 10 years, so be it, but now you've got the spot. The only thing I would recommend, check with your institution, make sure that they aren't charging you monthly fees if you have a certain balance, $100 or $1,000. Other than that, that's fine. Most people do that. Others, and so if you're the parents, maybe your parents or your child's grandparents want to start gifting. So I've done this for clients where I've worked with the parents, and their father gifted $50,000 to each of their grandchildren. He wrote a check to the Supplemental Needs Trust. I opened up a trust investment account working with the parents. He was only 9. Now he's 17. We more than doubled it. 27, 37, 47, there could be hundreds of thousands of dollars to be used later. Is that right for your family? I don't know. It's whatever you want. You have the flexibility. Also, it can own a home. You might make a case for that. Again, your son or daughter can own a home, but if they sold it, now the cash would be theirs. They lose their benefits. If the trust owned it, the trustee would sell it. Money just goes into the trust, checking, savings, investments to be used for whatever. So it's a good tool. If you're considering that, when most people do, and what I like, do it when you pass. Let's say for whatever reason you modified your home to be handicap accessible and you want your son or daughter to live there. You can do something, it's called the transfer on death deed for that property that says when we die, title of that goes into the trust. Sounds great, right? Because then the value inherited for the trust is at the date it was the time you passed. Let's say you bought it for $300,000, it's worth $500,000 when you die. The trust gets it at $500,000, pays 0 taxes on it. So again, it transfers very, very well. Now these are all things that are kind of advanced, but I want you to start thinking about them. It's all customized to you. There's no one best way to do this. It's for your family. So how does it work? We have a list of 50 common items what to use the trust dollars for. Basically, it's anything that's not covered by MA or Social Security. So what's that? Basic food and shelter, right? That's Social Security. Why? Because if you use the trust for that, then Social Security will say they're getting in-kind food and shelter. So they're going to reduce their Social Security. So don't do that. And also medical, well, if you're on MA, you wouldn't use it for that anyway. You don't need to. So it's basically, these are just examples. Anything that helps them makes their life as great as possible. And it has to be just for their benefit. However, because of their condition, they can need a chaperone. You can buy 2 airplane tickets, 2 hotel rooms, things like that, because they need it. All right. Make sense? Questions on that? Okay. Who's the trustee? Their sole job in life is to manage the money in that trust. That's their job. It's the only job that they have. In the documents, we want to name at least one successor trustee. So let's say co-trustees are mom and dad. Maybe it's a brother or a cousin. Ultimately, like someone who's younger down the line, so perhaps a sibling. These are just examples, family members. Sometimes we name a nonprofit organization to act as an advisor. I work a lot with Pacer in Minneapolis. They are not trustees. However, they know trustee organizations. They would work with the family, caseworkers to find a suitable trustee if you can't find a family member. There are professional trustee companies. There's about 4 or 5 of them in the metro area. We have a sister company that does that. These are all available to you if it doesn't work for your family. Trustee can be paid. Now, if it's mom and dad, and for my daughter, we don't charge anything, obviously. We have some that are siblings. They live up in Duluth, and they come down once a month. They charge mileage. That's reasonable. You can charge an hourly rate. $50, $100, whatever is reasonable. So difference between a trustee and guardian, I want to be clear on this. Okay. We'll name both of these people or organizations to make sure they're clear. Guardian, again, day-to-day activities, where your doctor or your child goes to the doctor, their person, whatever they're doing. Nothing to do with the trust dollars themselves. Can they be the same person? Sure. If it's parents, that makes sense. Sometimes, if it's down the line and it's siblings, you may have one be a guardian and one be trustee, kind of a check and balance. That may work, but it's whatever makes the most sense for your family. So, what happens to the money when the trust ends? The trust end goes for the beneficiary's lifetime, your child's lifetime. Trust ends when they die. There should be money left in this trust, unless you spent it all. How does it work? And I like to say it stays in the family. You control this. So this is a good planning tool. The money will stay in your family. Typically what we do, we'll say, well, if my child dies before me, it'll come back to me because I probably put the money in it, right? And then when I die, it goes out. A lot of times what we'll do is we'll say it goes to parents, and then it goes to siblings, and then we'd like to put grandchildren, if any. Even if they aren't born, and you do it as a group, you basically solve for 100 years potentially, right? Stays in the family. I think that's great. If you want to give it to anybody else, it's completely up to you. If you want to give to a church or charity, that's fine. So again, my opinion, this is the single best planning tool. The federal government instituted this in 1991, and Minnesota has this also. Again, maintain eligibility for Social Security and MA. Doing good? All right.
You can start one of those at any time.
Oh, yeah, when can you do this? Again, anytime. They have to have a qualifying disability. So if they're on MA and SSI, they have it. Yeah, you can do it anytime. A lot of times what we've seen is there's that event, and a lot of times it's when they're turning 18. Start thinking about this. Maybe we do guardianship and everything all at once. But yeah, you can do it anytime. I've had some families too where they've never been on a vacation without their children, and they're scared. What if something happens? So we've done this right before they went on their first vacation. Of course, nothing happened, which was good, but they had the peace of mind. Okay, so this is called a supplemental needs trust. Again, proactive, great planning tool. Money stays in the family. Now we're going to flip this over. You probably heard of something called a special needs trust, right? Minnesota is one of a very few states that actually calls them two different things. What's the difference? Special needs trust is what we call first party funded, meaning that came from your son or daughter. It was their money somehow. They got it in their name. So how could that happen? A direct inheritance. Let's say you didn't do any of this, you didn't know anything about it. A lot of times it's that grandma and grandpa who loved their grandchildren so much, in their will or in their beneficiaries, they gave money. Sounds great, right? But we just undid all of what we've been talking about. A lot of times, too, it's that crazy uncle, and I have one of those. It's my brother. I'm not kidding. He lives in Rapid City, South Dakota. He's a hermit. He just told me that, I'm sorry I have to tell you this, he drove 272 miles in a year and a half. He doesn't leave his house. He doesn't spend money. You can't talk to him about money. But that could be a problem. I talked to him. I said, Dave, I don't know what you're going to do with your money. I really don't care. But Claire can't get anything. I want you to know that. And he said, yeah, I thought you told me that once. He said, don't worry. I'm just giving it to my siblings. Okay, so that's good. I've had other clients where they didn't have any children, so they gave it all to their nieces and nephews. One client, $210,000 life insurance, 7 nieces and nephews, they all got $30,000. Great. His niece just lost all of her benefits. So these things happen, all right? Back payment from Social Security. Just dealing with this right now. We had someone who Social Security said, oh, you were disabled back to your 22. We're going to go back all these years. Here's a check for $60,000. Now all of a sudden they have too much money for what they just qualified for. Think about it. Doesn't make any sense, right? This happens a lot. Lawsuit settlements, traumatic injury at birth, that goes to your child's name directly. So we may have to react. And then Social Security, again, not being cheeky, they giveth and they taketh away. They make mistakes, sometimes for you, sometimes against you. It could affect you. So you should not have to do one of these. This is reactionary if one of these happens, or I call it the oops trust. Oops, one of these happened. So again, you shouldn't have to do it, but some people have both. They had this. This is solving today, and then for the future money, maybe we set one up with the parents' supplemental needs trust. Also, reporting. You have to give reports to the county, Social Security, Minnesota Department of Human Services Special Recovery Unit annually, how every dollar was spent. Why? Because they track every dollar, and the state of Minnesota is going to get it. So you don't want to do this. Depending upon where you're at, Hennepin County and Ramsey County, you may have to go to court 3 or 5 years to prove everything. This could be very onerous for you, so don't do it. This is interesting. With the special needs trust, after the beneficiary dies, you cannot pay for their funeral, but you can buy a prepaid funeral plan from the trust dollars while they're living. So a lot of times, as soon as we set these up, this is the first thing that we do. Just a kind of a weird thing. So again, don't do this if you don't have to. It's reactionary. Also, how it works. Trust ends when the beneficiary dies. Guess what? State of Minnesota gets all the money. Why? They know every dollar that you have spent. Some of you are on MA now. I just got a report today. Services that were covered. Literally, this is in the millions of dollars for your child. So they haven't leaned against it. They will take all of it. So this is not a spot to put your inheritance. You only do this if you have one of those events. Okay. Got the difference between the two? Yeah. All right, there's another one that might be a benefit to your family. Some ABLE account. Have you heard about this? Anybody have one? ABLE account? So I'll tell you how it works. And then there's a spot for it. I call it the sweet spot, and I'll tell you what I think that might help some of you. So the whole idea here is that we want to maintain eligibility for MA and SSI. Okay, that's its goal. So there's some rules that are pending. This might go away, but you have to be certified disabled before 26. I think that may be sunsetting in a few years. But let's say you had a traumatic brain injury car accident at age 30, you would not be eligible, right? If you're on SSI, you automatically qualify if you've been SMRT. It's also you're self-certified. I don't know why anyone would want to apply this that wasn't, but I've never heard anyone being denied. But you have to have a qualifying disability. There's some flexibility on this. So for people that are high functioning, they can actually open the account and manage it themselves. So I can see this. Makes you feel good. I have a job. I can put some money in here. I like that. And or an authorized individual. If you have power of attorney for your child, you could do it with them. Both could be on the account. That makes sense. Why? SSI and MA, you have to report this, but they're not part of the asset limits. You have to prove how the dollars were spent once a year. Other than that, it can work. Here's where it's not the ideal thing. It's subject to annual contribution limits, $18,000. So this is not a spot for your inheritance. Some of you have, you gift or you have a 529. This is exactly the same limit. That's the whole idea here. If your child is working, they can contribute, and this is actually the poverty level, $14,580 of their own money into this from their job. So again, if they're working, this makes some sense. The most you can have in this account is $100,000, otherwise they lose SSI. What's it used for? It's kind of the opposite of a supplemental needs trust. This is meant for the basic things, and I'm going to air quote, not the fun things. So it's meant for housing, food, shelter, education, college tuition, rent if you want it. So that's good. It's not used for concerts, going to the casino, and things like that. If you have a 529 plan, parents have this because they didn't know about their children, you can transfer this into the ABLE account subject to that $18,000 a year. So you can only do it in that increments. By the way, if you have a 529 plan, this is a problem for you. You have other children, you can simply change the beneficiary. Most people don't know that. It's another thing that might help you. How do you sign up? There's a state-sponsored plan. There's a link right there, savewithable.com. Big blue button says Minnesota. Tells you how to apply, or online or paper forms. There's also investment accounts. I think I manage about 6 of these. Just family choice, whatever they want. Most people do the state plan. So another negative, state of Minnesota gets all the money. Okay, so don't stockpile money in here. Sweet spot for someone who has a part-time job, which is great. They aren't making enough to get off MA and SSI, but they're making too much and they're having a hard time staying under that $2,000 limit. So they can transfer money into this account. You have to let Social Security know, but then it's okay. And so if you want to save up for that vacation, that car, that whatever, not a bad spot for it. Claire will never have one of these because she doesn't work. It's not important to us. But other people, it might be. So how does it all work? Some of the services that we provide. So if you're going to be doing all this, you need professionals, you need attorneys and planners to do all of this. And so we'll help you set up the wills and the trusts, put all this together, and then kind of manage this as time goes on. How much does this cost? People usually ask that. Depending on what you do for the planning, I've seen $2,000 up to $7,000, which I think is a bit silly in my opinion. Let's kind of prepare that. Guardianship, sometimes you can do it all free, but you have to work with certain attorneys, and it's kind of limited services. What I usually recommend is that you hire an attorney for you as parents. Fees for that generally $1,200 to $1,500. That would be the out-of-pocket cost. The cost to represent your child for a guardian, that court-appointed attorney, court visitor, will get those waived. We file something called informa pauperis, Latin term pauper or poor. Because they're not going to have many assets, they'll waive those fees, saves you about $1,000. So when I tell people budget for guardianship, just say roughly $1,500. Help you with that. So clients that we work with, some of you have seen this because you have one of these. This is a planning portfolio. It's kind of your guidebook for managing the trust, how it all works. So this is a playbook for you, but more importantly for successors. It tells you all of what you have done. So if someone takes over, you have that untimely death, you don't lose benefits for your son or daughter. So it kind of helps you get organized. So we have a website. There's downloads. How do I apply for SSI? Things like that, all free if you want to do all that stuff. And I think we're near the end. For those of you, and some of you have done this before, everyone that comes to this will meet with you for an hour if you want. Talk about your family and see if it makes sense for you to do all of this. And so if that's something you want to do, just let me know. I think my stuff is here, and then that's my phone number and email. So I think we have, 20 minutes, give or take? Yep. We'll take as long as we want for questions. So if there's any, otherwise I think we talked along. So yes.